public session. We have apologies from Deputies Pearse Doherty and Michael McGrath. Deputies Jonathan O'Brien and Barry Cowan are attending in substitution. And today we're considering the Public Service Superannuation Age of Retirement Bill 2018. I want to welcome Minister O'Donovan and your officials to this meeting. And I want to invite you now to make, if you have any introductory remarks to make in relation to the bill.
Thanks, Chairperson. First of all, can I thank the committee for facilitating committee stage of the bill, particularly given the level of interest that is in this from a number of public servants across the country. It's an important piece of legislation. Obviously, we want to try and have it finished before the dawn rises for Christmas. We understand there is a report stage slot available to us. There are amendments that will have to be recommitted to the Shannon. There are other parts of the bill, as we go through it later on, that have implications for people in respect of other schemes as well, that we're using this bill as a vehicle to try and get them accommodated. So, Chairperson, I just want to thank you and the clerks of the committee and the members for facilitating us here.
The bill then, Section 1. That's Section 1, stand part of the bill.
Agreed.
Section 2, there are a number of amendments. Amendment 1 in the name of Deputy O'Brien is out of order. It's a potential charge on the revenue. 2, Deputy Cowan is out of order. Potential charge on the revenue. 3, in the name of Deputy Daly and Wallace, out of order. Potential charge on revenue. 4, Deputy Daly and Wallace again, out of order because of potential charge on revenue. Amendment 5 is in the name of the Minister. Minister to move.
I move, Chairman, and the purpose of this amendment is to exempt the staff of the Central Bank from the provisions of the bill. The Government has agreed that the creation of a compulsory retirement age under primary legislation for staff of the Central Bank of Ireland isn't appropriate in line with the bank's autonomy in setting pay and conditions for staff as set out under the Central Bank Act of 1942. So I move.
Deputy O'Brien.
Yeah, Chair, I'll be agreeing with this, but it does give me an opportunity maybe just to speak on the section. Or,
yeah, you can go ahead.
Okay, just in relation to the section, as you know, Minister, there was a number of amendments which were ruled out of order, including one from Deputy Cowan next to me and myself. And that was in relation to a cohort of public servants who would be excluded from the legislation as it is, particularly those who are working under the circular at the moment. The policy advisor in my own office actually met with your officials, and I want to thank the officials for giving us the explanation, and it was a pretty detailed explanation of why they were being excluded. But I'm just wondering, Minister, if there's any prospect, or have you looked at it for a report stage to try and address those anomalies? If you haven't, that's fair enough, but I'm just wondering if you've given it any other consideration, given that there is a small cohort of people who are currently working under a circular who won't benefit from this.
Minister.
Chairman, thanks Deputy O'Brien, and I'd like to acknowledge as well the engagement that you've had with the Department, and I know that the amendments that you've raised have been ruled out of order, and I appreciate the concern that you've raised, and I appreciate the concern on whom you've raised it for. I think that in looking at the amendments, we've also sought the advice of the Attorney-General in relation to this, and while I appreciate the concerns, unfortunately it's not something that can be facilitated, because in devising the interim arrangement it was necessary to respect the current legislative provisions that these individuals were required to retire at 65 years of age, and they did so and received their pension benefits. The interim arrangements were established to offer a limited temporary solution to individuals who reached the age of 65 in the period between the Government's decision of the 5th of December last and the commencement date of the necessary legislation. If the arrangements hadn't been existed, this cohort of people wouldn't have been able to continue working. And not to labour the point that I said at the start, but we're very anxious that we would draw a conclusion and a line under this. The sooner we can get this enabling piece of legislation enacted, the sooner any others who could wind up in that interim arrangement will actually be facilitated by the passage of the bill. But I know that you're aware, because my officials have spoken to you, there's an awful lot of complicating factors here in terms of people that have already started to draw down their pension and where that would leave them, and people that haven't availed of the interim arrangements because they were told that this was only an interim arrangement. So people that would have already retired and gone and didn't avail of the interim arrangement. So on the basis of the legal advice that we've received and having reflected on the amendments that are there, Minister Donoghue has decided to proceed with the original decision of the 5th of December last year, which was that the interim arrangement would stand, and that pending the enabling of this legislation that we would move forward on that basis then.
Deputy Cowan.
Sorry.
Yeah, as Deputy alluded to, a similar amendment was ruled out of order. And an amendment coming up which acknowledges or preempted your decision with the view to preparing a report. Because ideally, when this, as you referred to, was published back in December of last year, there was an expectation on the part of many that they would be able to avail of an interim measure. But here we are a year later and it has not been enacted, and a whole cohort of people who had an expectation that the light has been turned out for them. And it's, while I acknowledged the amendments as proposed may well be a charge on the state, as is proposed here today, we are asking that you prepare a remedy or a suite of measures that may be possible within a few months, acknowledging the commitment that was made this time last year but unfortunately wasn't acted upon with the enabling legislation being enacted in time, and there be some procedure for those that are caught in that bind.
Chairman, look, I don't disagree with Deputy Cowan in relation to the length of time it has taken to get here, and that's why I'm appreciative of the fact that the committee has met today, and that if we can try and get a report stage finished next week, because we don't want to have a situation where it slips into January and another group of people who will retire at the end of December finding themselves in the same situation. Minister Donoghue, in his absence, actually, he sends his apologies. It was made clear at the time, I think, and everybody would accept that the interim arrangements for people that would enter into it were just that. They were interim until such time as we had enabling pieces of legislation enacted. And again, I go back to a previous point I made. There were a group of people over the last number of months who didn't avail of the interim arrangements because of what was said at the time, that they were just interim. If we're now proposing to say, we're going to reverse engines, where does that leave those who didn't avail of the interim arrangements? Where does it leave the pension contributions that have been paid? Where does it leave revenue? Where does it leave their point in the scale? So there's a huge amount of questions, and I know, in fairness to the deputies, they've engaged on this, but just in relation to Deputy Cowan's point there of the report and the amendment that he has down later on, and we'll discuss it, Minister Donoghue is prepared to accept in principle the suggestion that Deputy Cowan has made, but in doing so to flag and to point out that that may require legislative remedies.
Look, Minister, the reasons that were given by officials was, I think there was 3 reasons. One was that some of those public sector workers may not have been rehired in the existing role that they were in. They may be in new roles. The second one was that some of those workers no longer pay into the old pension scheme, and if they resumed employment on a permanent basis at the old salary scale that they left, then a new pension scheme would have to be put in place. You might just clarify that that is the case. And the third reason we were given is that if public sector workers were simply given the option of resuming work until the age of 70 under the same terms and conditions as is there now under the interim arrangements, we're being told that they would receive a significantly less in salary compared to workers who turn 65. And the argument was put forward that it's a principle of pay equality. Now, I find that a bit strange, given that we have no problem with 60,000 post-2011 entrants earning less than their colleagues for equivalent work. So I don't agree with that one. I think that one is a bit of a red flag. But the other ones, in terms of, do we have numbers of those public sector workers under the circular who are in the existing roles that they were in when they reached 65, or have started new roles?
So the interim arrangements?
Yes.
Yeah, approximately 450. And look, I don't disagree with you in relation to the length of time that it has taken, and I appreciate the fact that we're being facilitated today. And it has gone on too long, I accept that. The bill was published in July, and unfortunately we got to a situation where, you know, we don't order the business in the House for second stage and things like that. And I'm here today really, I suppose, to try and get this done as soon as possible. Notwithstanding the concerns that have been raised, legitimate concerns, but with pre-existing commitments as well, in respect of what was said when the bill was published, when the government's decision was made last December, and what was said in relation to those people who entered into the interim arrangements, which were, I think, well understood. But as importantly, if not more importantly, those people who didn't enter into the interim arrangements because that's what they thought they were, and that's what they were told they were, interim arrangements. So it would be desperately unfair of us now, given the number of people who retire on an annual basis, to rewind and say, you know, we're now going to have to reopen the whole thing, which would actually be one of the remedies that we would have to consider. And then the bill would probably be, you know, in a very difficult position. We probably wouldn't be able to carry it forward. So all of that new cohort of people who, as from the 1st of January, are hoping to be able to avail of this, they won't be able to avail of it. So that's the bind that we're in. But Deputy Cowan's suggestion, and I'll come to it when his amendment is raised, you know, we are prepared to lay a report before the Houses of the Oireachtas within 3 months, you know, or whatever is agreed pending the committee stage here, to see how this is working. But as in doing that, that may require legislative remedies, which we can't preempt at the moment.
Okay, so we're dealing with amendment number 5 in the name of the Minister. The question is that the amendment be made. Agreed. That section 2 then, as amended, stand part of the bill. Agreed. Agreed. Section 3, amendment number 6 in the name of Deputy O'Brien.
Just to remove the upper limit in terms of the age for retirement. It's a party policy that we're opposed to a mandatory age. So it's straightforward to remove the 75 years.
Are you pressing the amendment?
Yeah, Chairman, I mean, I wish to accept Deputy O'Brien's amendment and welcome it. Minister Donoghue has said, you know, while we're not specifying, and I accept Deputy O'Brien's principle that you know, we're not specifying that, you know, herding out of people at a particular age. In order for a legislative remedy, you have to have an age. So we're accepting Deputy O'Brien's bona fides in relation to 75.
Deputy Murphy?
Yeah, can I just ask a question? I mean, it's linked to the general question of the bill, because obviously I think when you look at it from the point of view of the individual, obviously we're not forcing people to retire if people want to continue to work, etc. But it does take place in a social context, and it takes place in a social context of attacks on pensions, cuts in pensions over years, and what starts out as something voluntary, and in this case something as voluntary plus with the agreement of the Minister, can over time morph into something that becomes the norm, and the fact that people are living longer and healthier and so on just goes to become a benefit for the employer, as opposed to people having, you know, long healthy retirements. So if it was linked to guarantees of decent pensions and so on, then fair enough. But I'd be interested in hearing both Jonathan and the Minister's response to that, but also the flip side of that in terms of the social context, and maybe it's a broader question as to whether the Minister has done any studies about if this was taken up, say not the 75, say the 70 was taken up by large numbers of public servants, what impact would that have in terms of recruitment? Because these are jobs that could go to people who are entering into the workforce. What kind of, has there been any sort of impact study done on that?
Minister.
Chairman, it's essential where regulation-making power is included in primary legislation that is supported by clear principles and policies specified in the primary legislation to guide the Minister in the exercise of that power. In this case, the new Section 3A3 contains a number of policies and principles to guide the Minister, such as evidence of an increase in life expectancy, consideration of the state pension age at that time, likely cost of the Exchequer, etc. In addition, the maximum age of 75 is included in order to further assist the Minister in the exercise of his power, and I have taken advice on this, and I am satisfied that the policies and principles are provided for in the new Section 3A3 are sufficient to guide the Minister in the exercise of that power. And in doing that, we don't want to be contradictory at one stage saying, these are new jobs and how many new jobs are we're going to prohibit, because the economy is expanding, the country's population is expanding, the public service is expanding. I would remind as well that this is a public service bill, so the employer here is the state. But as I said to Deputy O'Brien, we need an age. We can't leave it open-ended. And in that context, Deputy O'Brien's suggestion, the government doesn't have a difficulty with it.
So we're agreeing that it would be to prescribe an age being higher than 70 years and not put an upper limit then on it.
We're agreeing to your amendment there in page 4, line 10.
Yeah, which is to delete not higher than 75 years.
With an age at a report stage, is it? That what I get?
No.
No. Okay, sorry.
Just to answer Paul's question, there has been studies done. There was a deeper review done in November of last year. It was called the Review of Barriers to Extended Participation in the Public Service Workforce, and it actually gave a good analysis for and against extending it. It looked at 4 key areas: performance management, skills renewals, HR issues and savings. That is there, and there are some downsides to it in terms of new recruits, but it also focused on some of the positives, which would be the skills retention. Obviously, there is a cost then in terms of if people are working longer, there's a need for continuous professional development, and it talks about impacts on other legislation, making sure that grievances procedures are all age-proofed and stuff like that, but there is a report there.
I take that the amendment is agreed then? Agreed. Amendment 7 in the name of Deputy Cowan.
Thank you, Chair. Yeah, this is, as I just alluded to, discussing it before last, this report which would seek to address the unfairness associated with, as I said, the report, the legislation having been published this time last year as an interim measure with a view to it being implemented a lot quicker than it has. And on foot of the decision not to allow the amendment, on foot of it being a charge to the state, preempted that decision of yours by putting forward this proposal, which would seek to lay a report before the House within 3 or 4 months, highlighting an analysis of the options that are maybe available to correct this, the potential costs to the Exchequer in doing so, and also highlighting if, as perceived or mentioned earlier, there are potential administrative barriers to addressing this, what are they, etc. And I think that would allow us to be in a much more informed position than we are presently.
Are you accepting the amendment, Minister?
I am, Chairman, and in doing so, I'd like to point out to the committee that any potential remedies that might be available might involve legislative remedies, and in that context, any report that's laid before the House of the Oireachtas, it would be up to the Minister for Public Expenditure and Reform, obviously in consultation with others, to bring forward any potential remedies. But I'm accepting the amendment.
The amendment is carried.
Yeah.
Agreed. That's section 3 then, as amended, stand part of the bill. Agreed. Section 4 then, amendment 8 in the name of the Minister. 8 and 9 are related and will be discussed together. Minister.
Chairperson, thanks very much. These relate particularly to education staff. Certain staff in the education sector, such as teaching and learning staff, are not required to retire until the end of the school or academic year in which they reach the compulsory age of retirement. This is to ensure continuity of teaching provision throughout the year and to limit any classroom disruption. I think the committee would accept principally in relation to examination students. This arrangement is currently provided for in various pension schemes in the education sector, but the bill as currently drafted does not allow the continuation of this arrangement. On the recommendation of the Minister for Education and Skills, the Government agreed that this arrangement would be maintained in the context of the new compulsory retirement age of 70. Amendments to both sections 4 and 5 of the bill are being proposed in that regard. The amendment to section 4 is required in order that any service rendered by affected staff in the period between their 70th birthday and retirement at the end of the school year or academic year will be reckonable for pension purposes. The amendment to section 5 is required to ensure that where a statutory instrument or public service pension scheme provides for a compulsory retirement age, it will be read as meaning age 70 for relevant public service servants, or in the case of certain relevant public servants in the education sector, the end of the school year or academic year in which they reach that age. Both provisions are limited to public service pension schemes made or approved by the Minister for Education and Skills with the consent for the Minister for Public Expenditure and Reform.
Question is that the amendment be made? Agreed?
Yep.
Agreed. That section 4 is amended then as part of the bill. Agreed?
Agreed.
Section 5 then, amendment 9, already discussed with 8, that the amendment be agreed. That section 5 as amended stand part of the bill. Agreed?
Agreed.
Agreed. Section 6, that section 6 stand part of the bill. Section 7, that section 7 stand part of the bill. Agreed. Section 8, amendment 10, in the name of the Minister. This is a new section. 10 and 12 are related and will be discussed together.
Yeah, Chairman, thanks very much. 10 and 12 are related. The purpose of Amendment number 10 is to ensure that a salary sacrifice for employees under the Tax Savers scheme, this is the Transport to Work scheme, and the Cycle to Work scheme will not become liable for the new additional superannuation contribution. This is necessary in order for the treatment of the ASC to comply with the understanding reached with the public service unions in the context of the Public Service Stability Agreement 2018 to 2020. That the treatment of ASC would mirror that of the pension-related deduction. An amendment of the long title of the bill is required to take account of the amendment to the Public Service Pay and Pensions Act 2017 in relation to the additional superannuation contribution, and this is provided for in amendment number 12.
Okay, that section, the new section then be there inserted. Agreed?
Agreed.
Amendment 11 in the name of Deputy Burton is out of order. It's in conflict with the bill as read a second time on a potential charge on revenue. So that section 8 stand part of the bill. Agreed? The schedule then. Schedule be the schedule to the bill. Agreed? The title then. Minister, Amendment 12 already discussed with 10. I take it that the amendment is agreed. Agreed. That this be the title to the bill, an act to raise the age at which certain public servants are required to retire, to confer power on the Minister for Public Expenditure and Reform to raise that age by order, for those purposes to amend the Public Service Superannuation Miscellaneous Provisions Act 2004 and certain other enactments, to amend Section 29 of the Public Service Pay and Pensions Act 2017 and to provide for related matters. Is that agreed?
Agreed.
So the Select Committee on Finance, Public Expenditure Reform and Taoiseach has completed its consideration of the Public Service Superannuation Age of Retirement Bill 2018 and has made amendments thereto and has amended the title. The Select Committee now stands adjourned.
Chairman, thanks very much. Just to draw to the committee's attention, as the committee is aware, the bill contains a provision for a commencement order to bring its provisions into effect following enactment. I want to acknowledge the cooperation of the both houses in the bringing of the bill and its current position, and I understand the provisional dates are being allocated for report and final stages in the Dáil and for the bill to be recommitted to the Shannon later next week to enable it to be enacted before the end of the year. Rather than cause any further delay and to reflect the view of both houses that the legislation should be effective as soon as possible, I want to put down an amendment at report stage stage to remove the requirement for a commencement order. On that basis, the bill would become effective as soon as it's signed into law by the President, which is on the 5th, 6th or 7th day as it's presented to him for signature.
Deputy O'Brien.
Yeah, I mean, look, we're not proposing to put any amendments at report stage anyway, so we're eager to get this done as quickly as yourself, Minister, so whatever we can do to facilitate that will be done.
Thank you. Thanks again, Minister, and thanks to your officials. And as I said, the meeting is now adjourned for the day. Thank you.